See, I can be taught. Thank you very much. All right, and we're going to hear from the prime sponsor of HB 87FN and hear from Representative Dave Love.
Thank you, Mr. Chair.
How are you today?
I'm doing okay. How are you?
I'm all right. Beautiful. Okay, you have the floor.
Thank you, sir. For the record, my name is Representative David Love. I represent Rockingham 13, and I brought this this bill to the House because of something that happened to my brother, and he's here to let you know exactly what happened. But you know, with the invention of apps on our phones and stuff, you know, I've got Hunt Stand and OnX and stuff, and it gives you property lines. And quite often I'd be walking through the middle of the woods and there'll be posters, and there isn't a property line anywhere near it. People are posting land that isn't theirs, and the implications for Fish and Game, because they are so dependent on licenses,
Right.
it could be pretty huge in the future. You know, if I bring a young guy hunting with me and we can't find any land to hunt on, he's not going to go out and buy another license. You know, and like I said, Fish and Game is very dependent on licenses. I was just talking to Colonel Jordan. He said there's something obscure, a violation in statute, but you know, this will make it a Class B misdemeanor with penalties. And you know, a law without penalties is just writing on a paper, and we all know that. And this will put penalties to it. It's more or less the flip side of the coin of RSA. I think it's 635:4, where people caught taking down signs are penalized. They shouldn't be putting them up either, you know, where it isn't their land.
So people have been posting land without.
I'd say quite a bit of our land that is posted. I mean, there's no name, there's no owner's name, no contact information. Quite a bit of it is done by you know, animal rights activists and stuff.
And there, shouldn't all that information be on the posted sign?
There's room for it to be on it. You know, there's a line there that says owner, you know,
Right.
contact info.
Contact information,
Yeah,
yeah.
and you know, and a
And
lot of
hunters
it is never filled out.
Hunters, with all courtesy, would basically, you know, call and say, hey, can I hunt on your
Yes,
land? Yeah.
absolutely. You know, I've also found, you know, with these apps, that, you know, they'll tell you who the owner is, and I've called and, you know, people will tell me that, you know, I didn't post it, but go ahead and hunt it. So, you know, there's people out there that, you know, a neighbor that doesn't want people hunting, will put them up. Animal rights activists will put them up. You know, things like that.
So was this at all edited before it passed the House?
No, this is the way it went through.
Okay.
The way it came, this is the way it came out of OLS, you know, after I approved it.
Okay.
And it hasn't been amended.
Well, Senator, do you have a question?
Thank you, Mr. Chairman. Good morning. So I'm new to this committee. And I don't have any background in any of this. And I'm from Nashua, where you can't hunt.
Yeah.
Oh, you can't?
No,
Jeez.
You gotta stop.
but I was an English teacher. And so I'm wondering if you would be open to a slight grammatical edit for clarity.
What would that be?
Well, it would say, any person who knowingly places a sign or poster prohibiting certain physical activity on the land pursuant to RSA 635:A on any land for which the person knows that he or she has no legal right nor any reasonable basis. It removes that preposition
Yeah.
to, and I think just makes the sentence more clear that you can't post on land that you know you don't have a legal right to.
I would have no objection to fixing that. I've often said that, you know, commas and periods mean something.
Yes,
You know,
grammar,
especially in this business. It can make a world of difference.
So basically on line 8, you would strike 2.
Strike two, the word two.
and I would add instead of
That.
that, I would add the words, the person for which the person knows.
Okay,
Oh, yeah.
I
So-
just
okay,
think it
strike
would
that
make-
in too.
That would make the
Sure,
sentence
grammatically
more
correct.
clear.
Uh-huh, okay.
That you don't own the land and you have no reasonable basis to think that you do. But I do have a question
Certainly.
too, if I could. So you're adding a criminal penalty to this. I don't have any issue with the fine. But elsewhere in this 635, 4 or 5,
So, it's
is
six-
there a criminal penalty already?
There's a criminal penalty for doing the flip side of this, removing any signs.
There is.
Yes.
Is it the same criminal penalty?
No,
Class
it
B
isn't.
misdemeanor?
It isn't. It's a felony on the other end. But,
You're adding just a misdemeanor on this side.
Yes.
Of the
Okay,
equation.
thank you.
Yeah. So it's less, yeah.
there's still a good enough fine to get somebody's attention,
Sure.
you know, is more or
Yeah,
less what it is.
It's a big deal, though. I mean, you're actually usurping somebody's authority on their own property, and that's a
Sure.
big deal. Yeah. Max, you get that? All right. Any further questions? Seeing none?
We're good?
All right.
Thank you.
Thank you, Representative. Danich? Is it Danich?
No, it was Daniel. Is that?
That's a Daniel? We need to spell it. I'm just kidding. Go ahead. Come on, Daniel. Appreciate it. I'm gonna call you Dan. All right.
You can call me Dan. Yeah.
All right. Thank you.
Thank you, Mr. Chairman. So, as my brother alluded, what happened to me in November of 2023, I was hunting this land in Derry, which abuts the Derry Town Forest and has never been posted. And so I entered the woods off of Shapley Road, I believe was the name of it. But while I was in the woods, an abutter to this land put up 2 brand-new posted signs and then called the Derry police and told them that I was trespassing. And when the Derry police ran my plates, my telephone number appeared, so they called me. And I came out of the woods. And thank God there was a sergeant there because he was very reasonable, and I explained that these signs were brand new. Because if you drive down certain roads in Derry where there's lots of posted signs that actually litter every tree, but that's just, it's pretty obvious. Those people didn't want you on their land, but these were brand new. And I was able to prove that to the sergeant because it had been raining all week and they used sheetrock screws when they put them into the trees. So when sheetrock screws get wet, they rust. There should have been rust all over those posted signs, and there wasn't. They were brand new. And eventually, they determined that it was the neighbor who put these posted signs up after I had entered the woods. And then they called the police. And then I had permission from the landowner to hunt on that land. And I hunted on that land again, and again, they called the police. And a different crew of cops came out and were telling me that, now I knew that I was trespassing. And I'm like, that's not their land, they can't post it. And technically, if I'm trespassing on your land, your neighbor can't call the police and tell me that I'm trespassing. And if I was breaking a fish and game law because I was hunting, then it's Fish and Game that needs to arrest me, not the Derry police. And that sergeant said, well, he's right. And so the bottom line is what happened is these neighbors didn't want people hunting near their house, so they posted someone else's land. And as a matter of fact, the land that they posted is a deeded right-of-way to a new development that's not put in yet. So it's really a street where I was, or it's going to be. So the apps that my brother referred to shows the deeded right away and who owns the land, and that's how I was able to contact the landowner. And he still gives me permission, but yet the neighbor's posted signs are still up on his land because it's illegal for anyone to take them down but the landowner. So,
Interesting. Well, we'll see if we can move this along. Any questions from the committee member? Okay. Thank you very much.
Thank you.
Appreciate it. Colonel? Jason, you didn't say whether you wanted to talk or not.
I'm good.
Okay.
We support it. Morning, Mr. Chairman.
Good morning, Colonel. How are you doing today?
I am good. I am good. So Representative Love, Dave had reached out to me back before he wrote the bill and asked me about it. We talked about it, and I told him at that time, the only other law that we could use for something like that would be a hunter harassment law. And we have some good language for that. Difficult to prove, you'd have to have someone that you could actually see doing it. But this will be kind of the same. It's going to be difficult to prove, certainly, unless we get information or we know who it is. But I think it might work as a deterrent.
Yep.
It'll prevent people from doing it, which is good. So just so you know, if they put one sign up, which is what they typically do, they'll do it before Representative Spillane and I were just talking about this. They'll do it at a barway or parking lot to discourage someone from going in. And then call us. That's not enough to remove a person from the property. They shouldn't be removed from that. We would go there and say, listen, this is the landowner saying that, the alleged landowner saying you're not welcome here. And then we would determine whether that is the true landowner or not. So they wouldn't get a ticket for that, but it certainly harasses them.
Do landowners notify you of their posted areas?
They don't notify us of it essentially unless I get notified when they're having issues. If they're really intent on not allowing people on their property and people are violating that, they will reach out to us so we can monitor that. We have good relationships with the landowners. We don't promote posting, obviously. We want open land as much as we can get it. So if we see a newly posted piece, I've asked the officers to visit with the landowner, find out what the problem was and see if we could resolve it without limiting access to it. Because New Hampshire, we're very fortunate that we have a lot of open land. We're trying to keep it. This angers landowners. I have had complaints from landowners saying someone posted my property and I don't know who did it. I didn't want it posted and I didn't put those signs up. So it does happen. It does occur. And so if we had if we were able to prove who did it, this would give us a tool to charge them. There is a law right now under Title 20 in transportation. And I have it here. It's not I don't think it's a well-written for what we have. It's 23627. It's unauthorized posting and advertising. It says any person if any person shall in any manner paint, put upon or fix to a bridge, fence, or other structure upon a rock or natural object, the property of another without his consent, any device, trademark, advertisement, or notice shall be guilty of a violation. I've never used that in 30 years, so some of my officers are familiar with it. Most of them are not. So we do have something in statute now, but I think it's kind of weak. This would be a better law.
So come election time, that could be a problem.
Right, that's right. It would prevent, and I think it was more designed for things like that. Yard sale signs and those kinds of things, so.
Senator Rosenwald.
Yeah, good morning.
Good morning, how are you?
So did I understand you to say that if a landowner wants to post no hunting, fishing, trapping, whatever, which is their right
That's
as
correct.
personal property, your department tries to talk them out of that?
We don't try to talk them out of it. What I have found is if you have a piece of, I'll give you a better example of that. If you have a piece of property that historically in my patrol area was always open and suddenly I see brand new signs up, I like to know, I try to find out why that happened. What I worry about is did they have an issue with a hunter and it was not resolved to their satisfaction? Is that something we can fix? And if so, because a lot of times landowners will post their property, they don't really want to post it. They just don't want to deal with the headaches anymore. So if we can fix the headaches, I try to do that. I don't discourage them from doing that. In fact, we help them. We tell them if you're having issues and we can't resolve it and you just don't like hunting, fishing, or trapping, this is how you would post your property. We answer those questions all the time. I'm looking to resolve the ones that didn't really want to do it, that had another issue and felt that was their only recourse, was to post. And if we can prevent that, that's better for us.
As far as posting, it's supposed to be every 50 feet or something?
25 feet, under 635 in the criminal code, it tells you. So, in the way the courts have viewed this, it's kind of tricky, but the way the courts view this is if they consider, when you make these cases, would an ordinary person understand the property they're on is posted. So there's no requirement to measure those signs. The goal of that example was to say to people, make sure to post your property all the way around your perimeter, at all the bar gaps and openings. You don't even have to post your property to have people removed from it. So you as a landowner own 10 acres, you see a hunter on it today that you don't want on it, you could call me. I can go and I wouldn't charge that hunter because he didn't see signs. I would say to him, Mr. Avad doesn't want you on his property, so now you've been notified, you have to leave. If you return, I would now charge them with trespass, but that first time I would throw them off. If you're looking to charge someone the first time or to make it clear you don't want them on it, then you would be required to post it all the way around. People have been excused by the courts, for instance, if there's posting along the roadway, but the backside of their property was not posted and someone wandered in there and a landowner called us and we tried to make that case. You got to be able to prove that the average person should know that that sign meant, that it's posted, that property that you're on. That's the requirement. But there is a described, and we give it to people on the phone. It's, I can read it to you, but it's 25 feet. They have to be 2 to 3 inch block letters on the sign. There's a whole requirement for that, which kind of help. It's used as a guide more than anything else.
Senator Rosenwald?
Yes. As far as I can tell, it's 635:4.
That's correct.
And it says that the letters have to be at least 2 inches
Block letters.
and that it can't be more, the sign shall be posted no more than 100 yards apart.
Apart.
It doesn't say anything about 25
Yeah.
feet. But it also says that gates and
Barways.
entrances.
Right.
So we're using a different statute?
Nope, that's the one we're using. So basically, I've never seen a judge say to a landowner, well, you had them 110 yards, so it's not legally posted. What they look for is to make sure that the hunter, they use that as a guide so that landowners understand it's got to be posted in a very visible manner all the way around their property, where egress and entry could occur. And again, with the mindset that they want the ordinary person to be able to recognize they're not supposed to be there.
It's not 25 feet.
No,
It's
no.
300 feet.
That's right, 100 yards, yep, between them, yep. I think there was a requirement at one time to be 25 feet high or something, but it's just, it's mainly so that it's clearly posted around the property.
Thank you.
It avoids those places where there's one sign up and everyone's confused as to where the line starts and where it stops. That's the problem with
I
that.
swear deer can read.
What's that?
I swear deer can read.
Yeah, I would say that, well, they figure out very quickly where it's safe.
Yeah.
They are very good at that. That's why we have them in these residential areas and they're not dumb by
They're
any
not
stretch.
dumb.
But why do they keep getting hit by cars?
That's-
If they're
well,
that smart.
Yeah.
Right, true.
They've been eating some wild berries, I guess, and they're probably fermented. I know, I see it, I hate to see that,
Yes.
yeah. Seeing no further questions, thank you very much.
Thank you, sir.
Anybody else want to testify on this bill? Anybody care to speak up? Jason? You said no. You like it? Support it? I have all support for this bill. So you want to executive? Just kidding. With that, we're going to close the hearing, and thank you very much. Yeah, just a quick grammatical. Yeah, how are we doing on time? Wow. Good. All right, so Representative Spillane. Yes, sir. Are you next? I am. Relative to the use of air rifles for hunting game. Yikes.
I've got some handouts here for you guys too.
Are you going to include brass knuckles with this?
No.
Okay.
Taking game?
Yeah. Taking it. Pop.
I know Senator Furl's still in his signing, and so was Representative Cole, who was going to introduce with me, because it was his study bill that we did last year. To do a
Yep.
study on this.
Mhm.
Grab my glasses, grab my glasses.
Somebody's got to run the show, so I can't go do the signing. So.
There it is.
Hey, Howard, how you doing?
Cole should be here shortly. Thank you, Mr. Chairman, members of the Senate Committee. I come before you to introduce House Bill 655FN, which is, oh, actually, it's the wrong one. I'm doing HB 211. That's the next one. HB 211, which is relative to the use of air rifles for hunting game. This, as you can see from the handout I gave you, was studied last year from my committee in the House. We had a bill from Representative Cole that was to introduce the air rifles for hunting big game. And we felt we needed to study it, so we actually set it up as a study committee. And over the summer, we went and used SIG Arms facility with some equipment that was provided by Northeast Air Rifle. And we were able to do a full analysis of the capabilities of the rifles. And in the handout, you'll see some of the gelatin block penetration tests that we did, et cetera, et cetera. We then worked with the department to come up with a way to frame this so that it would give them the ability to shape rules to make sure that the proper rifles were being used. One of the things we stayed away from was designating calibers, because we determined during the actual using of these rifles that the caliber is not as much of a determining factor as how many foot-pounds it generates at the muzzle. And as an example, I think Maine did it wrong. They allow hunting with the air rifles, but they use a .30 caliber as the lowest caliber. And in our test, the .30 caliber did not penetrate far enough that we felt it was an ethical choice for most animals. It probably would be borderline for deer. I'll let the biologist from Fish and Game talk more about that. But the foot-pounds generated at the muzzle by this air rifle is far more determinative on its penetration and its lethality and its ethical ability to take down animals. So we've crafted this such that the amount of foot-pounds generated at the muzzle is the determining factor, and that is to be set in rules depending on the game being hunted by Fish and Game. So they can put a higher amount of energy needed for the taking of bear or moose and a lower level for white-tailed deer. We also included in the bill the ability for Fish and Game to create a tag for the air rifles, much like the muzzleloader. And I think it'll be beneficial for this committee if, when you think about these air rifles, you think about them as muzzleloaders that don't use powder but use air, because they are essentially the same thing. What we ran into is that these air rifles do not benefit the state through any Pittman-Robertson funds, and that's why we created the ability for them to create a tag so that they can have recovering of some costs to be able to enforce the air rifle usage. They've said at this point they don't feel like they will need it, but we know that they're always in budget issues, and they have the ability in this, and I would stress, please don't take it out. Leave the ability for them to generate that tag if they so determine in the future they want to.
You can buy an air rifle to take down a bear?
Absolutely. They went up to, I believe, a 54 caliber that we shot at the range. These are not air rifles like you picture an air rifle that you pump up. It's not your Daisy air rifle. They use a scuba tank to fill the tank on the gun.
I'm thinking of the movie No Country for Old Men, or old, what is it? Did I say that right? Yeah, the guy went around with a tank and he started blowing people up with a tank, an air tank. It's interesting. All right.
So in our studies, we found that the most shots you'd want to take before you refill your tank on any of these is 5, which is plenty because that's our normal amount that we let people go out hunt with anyway. The difference in air pressure from one shot to the next was not enough to cause a significant drop in the bullet over 5 shots. It was still essentially dead on. You were within about a half an inch. The colonel actually measured on the gel block and on one of the targets when he was shooting to see what the drop was. We specifically took those rifles to as far as we could to see where they would drop too much. And there was a question when we went into this of, well, how do you handle it when the temperature changes? Because as we know with Deflategate, that when it gets cold out, the pressure drops. And the answer was pretty a no-brainer from the air rifle company. They said, well, when you are out hunting with them, you fill them outside and you leave them outside. So if you're going to be hunting with it the next morning, you fill it outside in the cold and you leave it on the porch all night, and it's at the right temperature when you go out there. The responsibility to make sure it's charged up and everything was a question from some of the people on my committee. It's no different than making sure you put in the proper powder load for your muzzle loader. It is a requirement of the hunter to make sure that they're using their equipment correctly. And when used correctly, the penetration on the gel block, as you'll see from the larger calibers, went straight through the end, and that was probably an 18-inch long gel block. So the penetration was incredible. The velocity coming off of some of these, most of them on the first shot was around 1,100 feet per second. And that's even the 50 caliber and 54 calibers. By the fifth shot, they were down to about 900 feet per second. So the drop was not significant. And some of the rifles actually have a regulator that makes sure they dispense the same amount of air each time. Gives you the ability to be more consistent. Aside from that, I'll take any questions if you have them.
Senator Waters.
Thanks, Mr. Chairman. Good to see you.
Good to see you as well, sir.
So would you happen to have any statistics on the lethality at range comparative to, say, a 30 caliber rifle?
Well, when we start talking about calibers,
Yeah.
now we're talking apples and oranges, because I would compare the calibers that we determined were sufficient for hunting with the air rifle, which was like a 40 caliber, a 50 caliber, 54 caliber. We determined the 30 caliber did not penetrate far enough. So if we were going to compare that to, say, a 50 caliber muzzle loader, it is as lethal or more.
I guess what if I'm trying to get at is at what range?
We were
Is there
shooting at...
a differentiation in terms of lethality at range?
Correct. We took all of our test shots at about 50 yards.
Yeah.
And I would tell you that in all of my years hunting in New Hampshire, I have taken most of my deer at 35 yards or less, because we have thick wooded areas. It is accurate and able to take down deer as far as a muzzle loader. But one of the benefits we see to this is that we have some areas in New Hampshire that are high density. You can't use a rifle, but you could use an air rifle because it's more equivalent to a muzzle loader. It does not have the range. All right. So when you're talking about a 308, 2 miles away, that bullet is still traveling and lethal. A muzzle loader does not travel that far, nor does a shotgun. So we have some areas where they would be able to hunt with an air rifle, a muzzle loader, or a shotgun, and it gives people another option. Now, in addition to that, it's quieter. So areas like Governor's Island, where we have a deer problem, and currently it's archery only because nobody on the island wants the noise. So they don't allow the hunting with the rifles. An air rifle would be a valid option.
Okay, thank you.
Any further questions? Senator Pearl.
Morning, good to see you.
Good to see you as well.
So why'd you take turkey out?
We took turkey off because you can't take turkey with a rifle.
All right.
And they don't make any air shotguns yet.
All right.
Seeing no further questions, thank you.
Thank you.
Colonel?
Morning again,
Good morning.
Mr. Chairman, members of the committee. So we were not in support of this in the beginning. We had some real concerns about its ability to put animals down and wound animals. And so going to the range, spending some time with some of the different guns that are available and on the market today changed our opinion. Dan and I both went, the Chief of Wildlife and I both went. We saw the penetration factors. I thought it was very good, certainly adequate to kill a deer. We did ask the sponsors to allow us to set the caliber in rule because we had some concerns about just opening it up. I was a little surprised when the manufacturer told me 30 caliber was probably not enough for a white-tailed deer. That surprised me because it certainly is with a firearm. But it also, so we asked to set that and they gave us that ability. We would recommend that we start with a 35 caliber with 400, at least 400 foot-pounds on deer and bear, and then 45 for moose. working our way up. We're pretty confident that that would do it. What really was helpful to it, two things were helpful. One was I had a lot of questions about temperature, multiple shots, because you're losing air pressure each time that you fire this thing. I can tell you, Representative Spillane said it, but I shot it several times and the variation was very minimal. Probably no more than it would be from a hot barrel in a gun after rapid shooting. So I don't feel that's a concern. I likened it a lot to a muzzleloader, so people are gonna have to take the same kinds of care of it as you do a muzzleloader. You don't want a muzzleloader to get wet. You wanna keep it as constant, as in a constant temperature. These are no different, I think. I also, the one thing that kind of surprised me was the cost. So these are not cheap firearms. They're very, very expensive. And you've got to take the equivalent of a scuba tank with you to charge them. So I don't know how many people are going to be using them. My guess would be not many because of that. But we have other states using them. We were confident when we got done shooting them and talking to the manufacturer that they're safe, that they do have the ability to put down large game, and they're doing it across the country already. And then giving us the authority to set it and rule, I think, is better. So we can adjust on a very quick basis if we need to. So it was a good, it really was a good effort of all of us together. The other thing that the sponsors of this were concerned about was the fact that we would be losing the tax on a firearm. We now get Pittman Roberts money when people buy firearms and ammunition. We would lose that with this, so they gave us the ability in this law to create a separate tag for that in the rule. I don't know that we're going to do that, but it's nice to have that ability if these things become very popular and take off.
There's no fiscal note, really. I mean, there's no fiscal.
There really isn't, no.
Senator Waters?
Thanks, Mr. Chairman. Colonel, thank you.
Yes, sir.
So, as I understand it, in the language of the bill, that the air rifle will be prohibited in a compact area like any other firearm that is prohibited.
I don't think we put that in that bill.
Well, it says on line 29, if a person, or 28, a person is guilty of violation for the compact area of town, city, such person fires or discards any cannon, gun, pistol, air.
Oh, yeah,
rifle,
I'm sorry, compact area, yes. That would have, I'm sorry, I was thinking towns with special regulations. A compact area would be, it would be no different than a bow or any other weapon, that's correct.
And so, if I may follow up, just to refresh my memory, because of Representative Spillane saying that these might be used where a muzzleloader is permitted but not a rifle.
Is allowed, that's correct. These could be used in a more urban setting because they're quieter as opposed to a rifle going off. The towns with limitations haven't addressed this. We have a few towns that limit rifles. At this point, based on what I've seen, it's very similar in its trajectory and muzzle velocity of that of a muzzleloader. So I would say that it could be used under those scenarios. Again, it would be restricted from the compact zone, 6 continuous houses. You couldn't do that any more than you could a bow and an arrow. The other thing that the sponsors did in this, Senator, which was good, I think, is they put in language in this bill to describe or define what loaded means. Very similar to our other statutes. So they put some effort in making sure that these don't conflict with any of our other statutes. So it's very similar.
Thank you.
Yes, sir.
Mr. Chairman.
Thank you. Any other questions? Seeing none, thank you.
Thank
Colonel.
you, sir.
I have nobody else wanting to speak on this, so we will close the hearing on this. Is there a motion to move into exec?
So moved. Second.
Third? Okay. So there's a tie for that.
I'll move up there. Oh, we gotta vote first. Going to accept.
Yeah, all in favor of exec?
Aye.
Any opposed? Seeing none?
I'll move up to pass.
Second.
Discussion? All in
They did a
favor?
good job.
Okay, all in favor of about to pass?
Aye.
Any opposed? Seeing none?
Consent.
Consent by Senator,
Second.
by Senator Waters, seconded by, actually, she named it first. Senator Rosenwald. All in favor of consent?
Aye.
Any opposed?
take it up?
Yeah, you're on there.
All right.
Are we good on 87?
I think I'm okay with 87. There is a committee amendment that needs to be done.
You want to move on? I wasn't here. You want to move on to pass?
move ought to pass on
And I'll
House
se-
Bill
And I'll second
87.
that. And Senator Rosenwald has an amendment, a committee amendment of,
Just for clarity.
For
and
clarity.
style.
correct, 'cause she was an English
Which-
teacher?
Will change Roman 2 to say, any person who knowingly places a sign or poster prohibiting certain physical activity on the land pursuant to RSA 635:4, on any land for which the person knows that he or she has no legal right nor any reasonable basis. Just removes the awkward placement
Of the two.
of preposition.
Love it.
That's, thank you.
Were you a teacher too? No, I didn't pick up on you.
I was scolded by teachers.
Okay.
Um,
So was I had nuns.
But I think it's more clear.
All in favor of the committee amendment?
Aye.
Any opposed? And move on to pass as amended, seconded by Senator Rosenwald. All in favor of ought to pass as amended?
Aye.
Any opposed? Seeing none. Senator
Consent.
Pearls says consent. Senator Rosenwald agrees. And all in favor?
Aye.
Any opposed? Seeing none. And Senator Rosenwald, would you like to take this out, seeing how you did all the wonderful spelling corrections?
Sure.
Got it. We love
Let's
it.
hope it stays on consent.
As long as, it will stay on consent. Nobody will pull it off, I hope. Is there a motion to move out of exec? Seconded by Senator Waters. All in favor? Aye. Any opposed? Seeing none. Look at that. Max, you're doing a great job. Thank you. All right, and so we have a minute, right? 1 minute. 2 minutes, okay. So can you give that back to? And 5:08, yep, 5:08 is next, and that is.
Mark, you get a minute after the hearings?
Sure, happy to.
Thanks.
I am, Mr. Chairman, I am gonna go say hi to my school kids at 10, if we have a quorum,
Okay,
and I'll come right back.
oh, absolutely, enjoy. I got my guitar if you want me to sing to them. I do.
I'll open it up.
Yes, will do. Mhm. Man, my phone is blowing up. What? 318, 318. Okay. All right, so. Megan. That's a mouthful. Have you looked at this one already? Right. Have you looked at this one yet?
Seems de minimis, really. Let's see what they say.
Mhm.
I haven't heard anything from anybody about
I haven't either.
it. It seems okay.
All right, we're going to open up the hearing for HB 508 and hear from the prime sponsor.
Representative Harrington.
Representative Harrington, you have the floor. It is all yours.
Thank you, Mr. Chairman, members of the committee. Representative Mike Harrington, Stratford 18. I serve on the Science and Tech Committee. This bill is just a long overdue correction. It's pretty straightforward. It would have been on the consent calendar in the House, except we had a typo in it, and so we had to do a floor amendment. But the vote in committee was 18-0 in favor of passage. As many as you know, the regulated utilities are assessed a fee to pay for the regulation. This money goes to pay for the PUC and now the Department of Energy. And some time ago, we basically got rid of just about all the regulations on landline telephones, and we never had it on cell phones. So what this basically does is it says we reduce the amount that they have to pay quite a bit, down to 10%. And I think it was 33% before that. So This just puts in line what should have been done before, because there is virtually no regulation on landline phones, whether it's VoIP or any type of landline phone. So because of that, there's no sense in having them pay for the regulation that they're not getting. So right now, their customers, of course, has to pass that fee on, so their customers are paying for oversight, if you will, that's not there. And it's pretty straightforward, and I'll take any questions on it.
Senator Rosenwald.
Thank you. Thank you for bringing us this. Do you expect that the customers' rates for landlines, the few of us that are left, will actually be reduced, or will they just keep the difference as the cigarette companies did when we reduced the tobacco tax?
Well, I prefer to have the telephone companies themselves speak on what they're planning to do with the increase. I really don't feel comfortable speaking
Okay.
of what they may do.
Thank you.
Any other questions?
Further questions? Well done.
Thank you very much.
Yes, sir. Megan. So it says you're pretty ambivalent about this bill.
Good morning, Mr. Chairman. I'm Meg Stone with the Department of Energy. Sorry about my voice today. This is actually quite a bit better than it was over the weekend. But yes, the department is neutral on this bill, and I'm just here to give you some quick information and facts that we have on this. So the department currently assesses all regulated utilities and certain other utilities, including accepted local exchange carriers, VoIP providers, and providers of IP-enabled services for the expenses of the PUC, expenses of the non-federally funded functions of the department, supporting its regulatory obligations, as well as expenses for the Office of Consumer Advocate. The current assessment invoices to accepted local exchange carriers and certain VoIP providers they're based on 33% gross utility revenue, and this reduces it to 10% of gross utility revenue. It does not change the minimum assessment of $1,000. For fiscal year 2025, the department assessed just under $530,000 to 26 providers out of 171. And if the assessment had been based on 10% gross utility revenues, the assessment would have been about $158,000, just a reduction of about 371. And this would be transferred to other utilities, other regulated utilities, such as electric, gas, water, and sewer. And the department has a wide range of duties supporting telecom providers that are covered by these assessment funds. And I can just run through a few of those for you. The department does registration of new telecom providers, reviews daily requests for numbering resources, review analysis and recommendations to the PUC for new or modified interconnection agreements between the local telecom company and a competitive provider to provide or to confirm compliance with federal requirements. Review analysis and recommendations to the PUC relative to requests to modify franchise boundaries, annual certification of local exchange carriers for federal universal service funding, and resolution of consumer complaints. Those are just a few. We have a few more, but with that, I'm happy to take any questions.
Senator Rosenwald.
Thank you. Finance question. Did you guys, it says you contributed to the fiscal note,
Yes.
which claims there'd be less than $10,000 in any fiscal year. But you just told us over 300,000.
So that would be, so it would be assessed to the other regulated utilities, so there wouldn't necessarily be a decrease in assessment funds coming in overall.
Okay.
But I can look into what the fiscal note was. I didn't do the fiscal note, so I can look into that.
Well, so thank you. You'd be transferring $300,000 of assessment to other regulated utilities.
Yes.
Thank you.
Well done.
Wonderful. Thank you.
Chris.
Mr. Chairman, would it be all right if Teresa Rosenberger?
No. We all need a support system from time to time. It's off. Now it's on.
Mr. Chairman, members of the committee, thank you for allowing me to come before you this morning and provide this testimony regarding this bill. My name is Chris Rand. I'm the Vice President of Granite State Communications, and I'm here today representing members of the New Hampshire Telephone Association. NHTA is composed of internet and voice providers serving some of the most rural areas of New Hampshire. The companies I represent today are Bretton Woods Telephone, Dunbarton Telephone, Granite State Communications, and the TDS companies. NHTA companies provide internet and voice service to mostly rural areas, and we are close to 100% fiber coverage in those areas. The NHTA members have been deregulated since 2011, and in that time we've seen our interactions with the PUC dwindle to almost none. Today, the PUC sends 2 filings to the FCC on our behalf and receives the occasional consumer complaint. It's worth noting that in the 2011 deregulation law transferred consumer complaints over to the Office of the Attorney General. One stipulation of the 2011 deregulation included limitations on the frequency and the magnitude of increases to what's called basic telephone service. Also, at that time, by design, the PUC's responsibility for reviewing those price changes expired after 8 years. Today, the PUC is working on the Save the 603 numbering effort. This docket marks a shift to assessing docket participants rather than relying on the mandatory annual assessments. This also means that right now, the NHTA companies are paying twice, our annual assessment and the invoices related to this specific docket. Given this reduced activity, we maintain that the traditional assessment level is just not necessary, and moving from 33% to 10% better reflects the funding level necessary to support modern telecommunications oversight. By reducing the level of annual assessments, NHTA members will have more funds available to direct toward completing our fiber networks and also converting customers from the traditional landline onto those fiber networks. We are not seeking to eliminate the assessments, only to reduce them to reflect the PUC's reduced oversight of our industry. Thank you.
Teresa?
Teresa Rosenberger, I'm from Bernstein Shure, and I'm representing all the landline telephone companies, which also includes Consolidated and NHTA. I can't add much to what Mr. Rand said. However, I've talked to all the companies, and everybody, to answer your question, Senator Rosenwald, everybody will use the money for building out broadband. Everybody will use the money to build, and they all have plans to get to 100%. I mean, the money's not going into their pockets. It's only going in their pockets to go right out the door to build out fiber. And as Mr. Rand said, you all passed last year Senate Bill 595 and Senate Bill 603. This is the first time I had seen in a while that it was very clear in the law the PUC can assess the companies that are involved in those dockets, which means, as he said, the companies I represent are paying their annual assessment of 33%, but they also are being assessed the docket having to do with 603, and 595 is a docket dealing with the pole attachment rates. So as he says, we believe this is frankly double taxation. I have one company that hasn't heard except the filings. And all they do is file these, and then the PUC sends these filings to the FCC. I have one company that hasn't had any involvement probably in 5 years. And I ask all the companies to go back and give me every single time they had had interaction with the PUC over the last 5 years. And it was minimal, and I would say $158,000 would easily cover it. There is no staff. There's no PUC staff for telecom. So again, yes, when we were regulated, we were happy to pay. When we're not regulated, we are happy to pay this little minimal amount, but we're getting assessed anyway. So when they hire a consultant, we've got to pay. So we would respectfully, I will say, somebody said to me, why don't you guys take it down to 0? We were being magnanimous taking it to 10%. So we would respectfully appreciate it if you would reduce that to 10%. And thank you. I'll answer any questions.
Seeing none, well done.
Thank you.
And nobody else wants to speak on this bill? Going once, going twice, we're closing the hearing. Is there a motion to move into exec?
Move.
Seconded by Senator Waters. Is there a motion on HB 508FN?
Ought to pass. Second.
Discussion. All in favor of ought to pass on HB 508FN? Aye.
Aye.
Any opposed? Seeing none. Consent, Senator Pearl,
Second.
seconded by Senator Waters. All in favor of consent?
Aye.
Any opposed? Seeing none.
Senator Waters wants to take that up, didn't he?
Well, I'll take the next one out.
I was going to ask, Miss, would you like to take this one out?
I'd love to.
All right, so Senator McConkey is going to take this one out. All right, and motion to move out of exec? All in favor, say aye.
Aye.
Any opposed? Thank you. All right. And,
So we've got a few minutes. right?
yep, got a couple minutes.
Let me tell you about something, if I may.
Yep, let me shut off my mic. Okay, we're going to open up the hearing on HB 655 and hear from the prime sponsor. Seeing how we have no prime sponsor? Move to, oh, we do have somebody. All right. We run a tight ship here. Representative, you are recognized.
Thank you, Mr. Chair, members of the committee. Nice to see you again today. This bill you'll find a little bit boring. It was a request of the department. But there's one very interesting part, and I will tell you the story about that, because I had to add a non-germane amendment to it with agreement of the department over on my side so that you could have the entire bill as one housekeeping bill. So in general, we asked during the special committee that we had over the summer to look at long-term financing for Fish and Game. We asked them to go and look at all the different things that hadn't been touched for fees and fines and such in so long. And they realized that the restitution fees had not been touched in a very long time. So this is increasing the restitution fees to something more reasonable in today's economy for restitution that is paid when somebody illegally shoots an animal. So essentially, if somebody goes out, I won't say Howard did it, but if somebody goes out and shoots a deer out of season and they're caught, they're supposed to pay restitution to the state. It was also a may pay, and often the judge would ignore that. And I believe this does change it to a shall pay. So they will be paying the restitution. It's not an option for the judge to decide no restitution anymore. The state will get the money back. In addition, in order to try to deter some of the poaching, it increases some of the license suspension time and the penalties for violating that if you do it on multiple times. So you can actually have misdemeanor charges and things after multiple times. And that's the meat of the bill. In it, at the very last item, item 4, if you look at the amended analysis on the bill, removing the requirement that a crossbow permit issued for certain persons with a disability be perpetual. This came about because I got a call from a constituent, not actually in my district, but a constituent nonetheless, who was looking to try to solve an issue that he had with the department, in that many years ago he had a shoulder injury, and it was a permanent shoulder injury, so he got his permanent crossbow. He could no longer bow hunt. He'd been a lifetime bow hunter, and he hated that he had to give up his bow, but he couldn't draw it anymore. So he had a lifetime bow hunt permit for permanent disability. And unfortunately, it's not a lifetime license, but it was a permanent disability permit for the crossbow. Let me clarify that. When medical science has advanced, they were able to fix his shoulder. He was given the clear to go and bow hunt. And when he went to try to get a regular bow hunting license, they said, you can't. You got the crossbow permanent disability, and it says in there that you'll have that in perpetuity. So you may never go back and shoot with your regular bow again. You can't hunt with that bow ever again. And I said, boy, that's not how we intended this to be. The in perpetuity was supposed to just mean you don't have to come back every year and prove you're still disabled. And I talked to the colonel, and he said, yeah, we didn't intend that to be you can never get better and never hunt with your regular bow again. We just didn't want the person to have to come back every year and prove that they're still disabled. And the people in the main office said, well, we still can't do it unless you take the word perpetuity out. So this amendment changes the permanently disabled to not say in perpetuity, so that this guy can have his regular bow hunting license back, and anybody else who runs into this that he gets healed can go back to shooting with a regular bow instead of being stuck with a crossbow forever.
Questions from the committee? Senator McConkey.
Thank you, Mr. Chairman. Thank you. Nice to see you here.
Yep.
So I'm sorry I missed the very beginning coming back in. So with this change, the people that are hunting with disabilities still, it's changed enough so that they don't have to come back every year and prove their disability.
Right. They still get a permanent disability, but it doesn't say that that license is issued in perpetuity.
Right.
It's just a permanent disability designation. And if they come back and say, I'm better now, we'll let them go back to their regular bow hunting license.
Thank you for the clarification.
Thank you, Mr. Chairman.
Senator Pearl.
Thank you. Thanks. Thanks for coming in today. So by changing this may to shall, do we create a situation where someone accidentally takes a deer and, you know, it might be a situation where there's 2 deer aligned and the second one shot accidentally? Are we then forcing a judge to apply a penalty to them and not giving them any latitude?
My understanding is it would only if it ends up going to court and was not handled under the department with the discretion of the director, which oftentimes those types of multiple shootings are handled within the department and they don't take the person to court. But I'll let the colonel flesh that one out even more for you.
I kind of had an idea it might go to him, but I thought I'd start with you.
Absolutely.
And I think you answered my second question, was that this doesn't create a barrier for a person, say that had an injury, was healed, and then, I don't know, if some misfortune had a situation later again where they needed to go back to a crossbow, they're able to do that?
Yep, I think they would have to prove the new injury, but that's it.
Okay, thank you.
So, Senator Rosenwald, is there any proofreading that we need to fix on this? All right.
Thank you. Thank you for taking my question. So if somebody has the disability crossbow permit, does that mean for at least 7 years, they don't have to get a new license every year? Like
They
what
still
if-
buy a license every year, but they have a
Still.
permit. The permit allows them to use a crossbow during regular bow season. So instead of hunting with a regular bow, they are hunting with a crossbow during the regular bow season because they've got a disability.
Okay, but they still have to buy a license?
Unless they buy themselves a license.
Okay,
Yeah, a lifetime license.
Got
If
it.
you buy a lifetime license, you still have to buy certain tags every year, but you have the license. And the bow license is one that you have to buy separately, the archery license.
thank you.
All set? I'm good. All right. Seeing no further questions, thank you very much.
I'm sure the rest of your questions will be answered in a minute.
Colonel, can you make this unboring for us?
So good morning again. For the record, Colonel Kevin Jordan from Fish and Game. The commission actually started this bill, the penalty section of it. So I had a commissioner come to me because he was frustrated that we were getting repeat offenders and we didn't really have a statute to address that. So someone could shoot a deer illegally, be fined $240 this year and do it again next year and be fined another $240, and we weren't making any enough of a penalty for that second or third offense. So he came to me and we kind of discussed upping the fines. I told him some of the concerns with that. We get to a point where officers don't want to issue the fines if they go too high. We've kind of seen that in the state. So I suggested looking at restitution, because we used to try to institute restitution for that money to come directly back to the department in support of habitat or our game animals. And the courts were kind of hesitant to do it. They saw it as a negotiating tool because the law said may. So they wanted to change it to, we suggested changing it to shall, and then upping those amounts. So that's where that came about, was to address that. Again, we would have, I think, the discretion to ask the court to do that. I don't think it's an automatic thing for a court to do. Arguably, a judge could know about it and say, I'm going to do it, and you couldn't stop it. But I don't think they do that unless we asked. That's been our experience. The best part of this bill is the enhanced penalty for second and third offense. So we have, if you lose your license, you commit a hunting violation the first time, it's a year loss of license. Again, that's subject to a hearing and our discretion, but typically it's a year loss of license. Second offense within a 3-year period a 5-year period would result in a 3-year loss of license. This bill takes it a step beyond that and makes it an habitual offender, puts in an habitual offender status, which is long overdue. We are making cases. I've hired a bunch of little techies. These new kids can't talk to you, but they know technology, and they have started a whole new frontier of enforcement by going into cell phones and computers with search warrants. In fact, we're doing one tonight. So they're going back and they're finding offenses that have occurred 4 and 5 years ago. and they're bringing those forward. So we're getting a lot of multiple offenders. So it's certainly a time to address that, to have a heavier penalty for that. So we're in the commission and the department certainly is in support of that piece of it. The other problem that Representative Spillane talks about was an individual came to us. In the time I've been at Fish and Game, I've had this happen a couple of times where individuals have been deemed by a doctor to have a permanent disability. And therefore, if the doctor signs off on the appropriate paperwork, they meet the requirements for that disability, they are now able to use a crossbow in place of a bow. The law was also written to prevent them to going back, so they were limited to that crossbow because they needed it because of their disability. We've had 2 occasions, this second one that he speaks of, I was involved in, being the only second time it's ever happened, where medical advances have reached a point where this individual's injury could be repaired. So he wanted to go back to a bow license. Law enforcement didn't have an issue with that as long as they had a license. It doesn't matter to me if it's a crossbow or a regular bow, but the law was pretty clear that it was in perpetuity. And I think the reason it was written that way was we require on the first application for a person to jump through a number of hoops to prove they're permanently, and the word is permanently disabled. So my folks downstairs struggled with that. They said, well, if it's permanent, then how can they get better? That's a pretty good argument. I couldn't reason with that. So I said, if we just struck the language of in perpetuity, and the reason that was put in was to prevent people from coming in year after year to prove that disability each year. So if I have a disabled crossbow permit and I have a permanent injury, the argument was made back when that law was created that they would have to prove that over and over every year they applied for that. I don't know that I accept that. If you have proven you're disabled and nothing has changed, I don't know why we would require that. So we decided to strike that and let these folks that want to go back, that say I'm better now and they want to go back to a bow, go back to a bow. I don't think they're going to jump back and forth, and as long as they're licensed, I don't know what the issue is, to be honest with you. But our licensing division felt with that language in there, we couldn't do that. So I asked the chairman to write that in an amendment so we could strike that piece of it, and he did that. So that'll cure that problem.
Senator Waters.
Thanks, Mr. Chairman, and thank you, Colonel.
Yes,
So,
sir.
On the restitution, are you responsible for collecting that or the courts?
No, the courts will collect it and forward it back to the
And the
department.
fines?
And the fines too, yes, they collect all of that.
And do you anticipate much, well, it's not you don't have to worry too much about it. I was wondering about, because of search and rescue difficulties of collecting.
No, because the court has the authority to put people in default if they fail to pay their fines, so we would have that. I don't have that authority in search and
And
rescue,
the
so we struggle.
restitution funding, if I may, will come to the department.
Yes, yes, it will. Yeah, it was put right in the bill.
Good. Thank you.
Yes, sir.
Senator McCarthy.
Thank you, Mr. Chairman. Colonel, thank you for taking my question.
Yes, sir.
The pass-through on the fines, does the court take a cut of your fine when they do that?
They do. They take a small percentage of it, yes.
Small percentage, something less than 20%?
Less than 20. I'm struggling trying to remember what it is, but it's a small percentage. We get the majority of it.
Thank
Yes,
you, sir.
yes.
Would
And
it be a
restitution
benefit would it be a benefit if you received more of that?
It would.
Thank you.
It would.
Senator Rosenwald.
Thank you. And good morning.
Good morning.
So some years ago, a gray squirrel ate through a screen window in my kitchen and came into my house,
Ooh.
where I was illegally possessing it, I think, because
Kind of, yeah.
it was trespassing.
He was a
but-
squirrel.
And I hired a company to come and put
Remove
out a
it.
trap.
Yep.
I don't know what they did with it
Okay.
when it finally entered the trap, but would I, as a homeowner, be subject to fines for legally possessing
No, ma'am.
gray squirrel?
No, ma'am. No, in fact, in New Hampshire, thankfully, we can protect our properties. And so a lot of those laws are exempt, frankly. There's an exemption put in for landowners protecting their property. In that scenario, you didn't possess it. It came in on its own. So it was,
Okay.
yeah, you are not violating any law.
Okay, thank
No.
you.
And if they use brass knuckles, that would be a problem.
Right. Right. Yeah. They can do a lot of damage. I think Senator Pearl could share some of the damages in a maple sugar orchard that they can do.
Now use a 50 caliber air rifle.
Yeah, yeah, there you go, of air rifle. Yeah.
All right, I have nobody else wanting to speak on this, and you made it very colorful. Thank you very much.
Thank you very much.
It's not boring anymore.
Not boring.
Now, Cindy, you would be able to take that squirrel with a crossbow.
Yeah, exactly.
An air rifle now.
All right, we're going to close the hearing. Is there a motion to move into exec? Seconded by Senator Waters.
Come McConkey.
Oh, McConkey, I didn't hear you. I'm sorry.
I'll move to pass on 5655.
We got a vote to go in first.
Oh,
We did.
sorry.
No, we didn't vote
Yeah, we did.
to go in. No, you just had a motion.
Okay, it was seconded by Senator
McConkey.
okay.
All in favor?
All in favor of exec?
Aye.
Any opposed? Seeing none. Motion by Senator Waters to ought to pass.
655 ought to
Second.
pass.
And all in favor of ought to pass?
Aye.
Any opposed? Seeing none.
Consent.
Second?
Senator Waters and then Senator Pearls. And all in favor of consent?
Aye.
Any opposed? Seeing none. Senator Waters, you are a co-sponsor.
I am.
Would you like to take this one
I
out?
do. I do.
And it is so moved. The consent. All in favor of consent, just making sure.
Aye.
Aye. Any opposed? Seeing none. All right, that being said, is there a motion to move out of exec? All in favor, say aye. Any opposed? Seeing none. Thank you very much.
Done?
Done.
Done.
All right. Good. Thanks, Max.
There wasn't a pecan nut pie on the other side of that screen, was there? You weren't luring them.
Or, yeah, exactly, right? Baiting, yeah.
As long as you don't use a 50 caliber air rifle.